So I'm going to tell you right from the get-go, he doesn't admit anything. There's not going to be a deferred sentence. If he wants a trial, that's fine. His statement is anything but honest. Probation is for people that admit they did something wrong. I'm only willing to bend reality so much to grease the wheels of justice, so to speak. I get lied to so much. I'm going to take that short recess.
This is Judge Cooney in Grand Traverse, Michigan. I haven't covered him before, but he shares one defining trait with all judges in general. He does not appreciate being lied to. So we see. It's made all the more unpalatable by the defendant who is trying to squeak by with a no-contest plea to beating the hell out of his old lady. No way Judge Cooney is going to let that happen anyway, but even after the defendant and his lawyer come back from the bullpen, Cooney feels like everyone is leaving him out of the loop. So he reacts. Let's roll, nerds.
Right, Ms. Claxton, are you ready on Nicholas Johnston? That is file 4141 of 2025. And Mr. Johnston, Ms. Claxton is here on the defendant's behalf. And this is the date for sentencing on defendant's conviction of domestic violence, with the understanding there would be a deferred sentence. So, Ms. Claxton, have you had an opportunity to review the pre-sentence report with your client, and is it accurate and complete?
Your Honor, we have had a chance to review the report. We don't have any factual corrections.
Okay, so I'm going to tell you right from the get-go, he doesn't admit anything. There's not going to be a deferred sentence in this case.
And Your Honor, I think he fled the contest originally because he doesn't remember everything because he was drinking.
Well, he seemed to remember things when he talked to the agent, because he says he doesn't fully understand what his wife told the police, thinks she lied about some things. He said there was no physical altercation. So there will be no deferred sentence. If he wants a trial, that's fine. Do you want to talk to him some more?
Yes, Your Honor, thank you.
All right, are you ready, Ms. Claxton?
I am, Your Honor. Appreciate the time to speak with my client. Your Honor, in speaking with my client, I think there's a miscommunication here. He is talking about the night that he was arrested when he said there was no physical altercation. He does admit that there were hands placed on the victim the incident prior, which is what she reported when the police came.
You mean when her wrist was broken?
Correct, Your Honor.
So he's denying that he threw a Tupperware full of food at his wife, striking the mother-in-law, or pushing into the wife.
I believe that missed hitting anyone.
Yeah, it's on the ground outside.
Hitting his mother-in-law is what the report says.
It says, but missed hitting his mother-in-law.
Well, but missed hitting his mother-in-law, but he's denying that.
No, he admits it, but he's saying there was no physical altercation. He means that he didn't place hands on the victim in this case, Your Honor, in the night that he was arrested.
It was a week and a half, I think, prior that there was physical altercation.
And I did notice, Your Honor, above recommendations that probation did reflect that the defendant was honest and remorseful for the situation.
And I would strike that sentence because his statement is anything but honest.
And I think it's a miscommunication.
Does your client want to withdraw his plea and we'll have a full trial and I'll figure out exactly what happened here?
No, Your Honor, he admits that a week or two prior to this.
Because probation is for people that admit they did something wrong, and then there's a reason to put them on probation and offer services. But if they said they did nothing wrong, I'm only willing to bend reality so much to grease the wheels of justice, so to speak. And I tell people when I take these no contest pleas, don't come in and tell the probation officer I didn't do anything. If it's because of alcohol consumption, fine, tell me you don't remember anything, but don't sit there and tell the probation agent there was no physical altercation.
I told her there was, Your Honor.
No, you didn't, or it would be in the statement.
All right, I'm sorry.
Do you want me to get my probation agent up here?
Nope. All right.
So your client wants to go ahead with sentencing.
That's correct, Your Honor, and he does admit that prior to this night when the police were called, that he did place hands on the victim.
Okay, then let's go ahead with sentencing. What else would you like me to know?
Thank you, Your Honor. Your Honor, as you can see, this is his first assaultive charge. I think, but for him having a relapse and drinking, I don't think he would probably be back before, Your Honor. He's really disappointed in himself because he did go through the sobriety court program and he was successful in the sobriety court program. Unfortunately, he's had a relapse in this situation. He, however, has been on twice daily PBTs. He's been fully compliant, no issues are noted with bond. I think that shows that he is someone who can maintain sobriety. It sounds like CPS was also involved with this and has recommended some substance abuse services, which he's fully willing to do. It sounds like prior to this, he and the victim were in counseling, and he would like to get back into counseling with the victim when the no contact order is lifted. I know it's noted in the recommendations that we lift the no contact order, at least for communication for child care purposes. We'd ask that after the classes are completed, the 3 classes, that be reevaluated if the victim is willing. But Your Honor, I think that this is someone who has proven in the past that he can complete a probation. I think he needs to get his services back in order so that he maintains his sobriety and that he isn't back before Your Honor. So we'd ask that the court follow the recommendations in the pre-sentence report.
All right, Mr. Johnston, is there anything else you'd like to add?
I just, with all this going on, I feel like it was a new kind of like a rock bottom, and I just want to move forward and use it as an extra stepping stone and just go from here, get back on track. It's been tough, and I've done the sobriety court program, like Ms. Claxton said, and I have the tools, and I just think, this is just another tool, and I think it's something I needed. Things happen in this world for only God knows why, and I think, I'm not arguing with it or anything like that. I think it's, the services CPS is offering sounds like a really nice, so once a week meet in person with like addiction therapist, I believe, and then I've heard a lot of good things about this men's group as well. So,
all right, thank you. Is there a victim?
Yes.
Okay, so Ms. Johnston, if you want to come on up to the podium, I would like to hear what you have to say.
I'm right nervous. The night in question, there wasn't a physical altercation. It had been.
You know why I'm upset?
Oh, no, I'm sorry.
Because I get lied to so much.
Oh, yes, sir. No, I'm not lying. No. It's something.
And it gets tiresome. I'm going to take a short recess here.
All rise, please.
All right, we're back on the record in People versus Johnson. Please be seated. I'm going to adjourn the sentencing today. I'm going to do my own pre-sentence investigation, and we're going to come back. I'm not going to try to make decisions today based upon statements that I'm very suspicious of, and I don't feel that I know all of the facts here. So I'm going to review the facts myself, and then we'll come back. And Ms. Martin, you want to pick a date for
Sure.
sentencing? The no contact order remains in place.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me, and let me know what you'd like to see and how I can improve. Thanks.